Welcome to our fourth lecture on disability discrimination. We're going to begin talking about special topics. In our previous three lectures, we did a general introduction to the topic of disability discrimination. We talked about how the prima facie case is made by the plaintiff in ADA cases. We went over a lot of vocabulary and then we applied the vocabulary in the reasonable accommodation process. And we talked about special categories of disabilities and how the law treats those situations. And at the end of our last presentation, we discussed the topic of remedies, what a successful plaintiff may be entitled to at the conclusion of the lawsuit. In this section, we're going to discuss some special topics. Some of these we've touched on before, some of these will be new. So let's begin. I like to call this section the fine print because we're going to get into some details of materials that we discussed in more broad strokes earlier in this presentation or perhaps in earlier presentations. So we have talked a little bit about hiring in previous lectures. We talked about the process by which somebody becomes an employee and what the risks are associated with that. Let's talk about how the Americans with Disabilities Act impacts the hiring process. As we know, the ADA does limit an employer's ability to inquire about physical or mental conditions that the applicant might have. Sometimes those conditions are obvious. A person comes in a wheelchair or comes with a sign language interpreter, and it's pretty obvious that they have a medical condition. Sometimes the applicant volunteers information during the interview process. But many times there will not be any information about a disability until the person might be hired. So let's first of all consider the situation where it's obvious that this person has a disability. How should we handle that interview? Well, the short answer is that you should handle it just as you would any other interview. You would ask the same questions. And that's the way that I like to advise interviewers so that they're prepared for this. And many times they won't have any advance notice. They may have scheduled an interview and may have no idea when the person shows up that the person will have a seeing eye dog with him or her, or that person will be a wheelchair user. And so my suggestion is to proceed with the interview just as the interviewer would have proceeded with another individual through the interview process. There shouldn't be any questions about the physical situation other than things that are just kind of basic, like, is that seat comfortable for you? If they are transferring, say, on into a seat, or is there anything I need to know that I can help you with? Um, Along those lines, but I would not discuss how the person became injured, whether this injury is a permanent situation, what type of treatment or condition might be in play in that situation. So that's the way to approach that. And then after that first interview, the interviewer may have some questions, such as how will this person ever be able to do the job? Well, instead of asking the candidate that question this time, that's when an attorney needs to be involved. And so the interviewer and the attorney need to get together and talk about the precise words that need to be used to get at the particular questions that the interviewer has. In most cases, the interviewers can get the information that they need, but the questions have to be very carefully worded and very carefully planned. And so that's why it's not a good idea to have that in that first interview when the interviewer is naturally surprised and not quite sure what to do next. In the second situation where the interviewer doesn't know anything about the disability, obviously the interviewer will handle the interview just as he or she ordinarily would. But the interviewer should always assume that there's a possibility that this particular interviewee may have a disability. And so you always have to be careful about the questions that you ask because you don't want to inadvertently ask about a disability. The EOC has very detailed guidelines about how these types of questions can be answered. As a general rule, you can't ask disability related questions until after a conditional job offer has been extended. And so that's something that you would talk with the attorney about to see, do we have to extend in a job offer before I ask additional questions, or can I ask some additional questions before I extend the job offer? And the short answer is that it is possible to ask some questions, but they can't be disability related questions. They would be questions about how this particular person would accomplish the job tasks. So, again, it's an artful, delicate procedure requiring a lot of sensitivity, a lot of tact, and also a good understanding of where the legal lines are. Now, one thing that is important to keep in mind is that the ADA does not regulate drug and alcohol tests. So, really, there aren't any limitations in what an employer can do under those circumstances. There is no need to wait to offer a drug or alcohol test until a conditional job offer is made. So, that is something to keep in mind. One thing that sometimes comes up is clients may ask, well, what if I have two equally qualified candidates and one is going to require an accommodation and the other one isn't? I would prefer not to do the accommodation because it's going to involve significant expense. Since it's a tie, can I go ahead and hire the able bodied person? The answer is no, you may not. You can only hire the able bodied person if the able bodied person is the more qualified candidate. If there is a tie, you cannot use the able bodiedness as a tiebreaker. If you have to figure out some other tiebreaker. If the disabled person is the person who is the better candidate, even if the expense is significant but doesn't, of course, qualify as an undue hardship, then you need to hire the disabled person. So let's consider this scenario. So Mary and Bob are applicants. Bob is disabled and he is a wheelchair user. Mary, as far as the company knows, has no disability. They're equally qualified for the job. Under these circumstances, the employer can't choose Mary simply because the company is going to have to spend some money to alter some aspects of the workplace so that the wheelchair that Bob uses can pass down the aisles. That would be an example, that would be a violation of the Americans with Disabilities Act. So during the interview process, employers may ask applicants whether they can perform the essential functions of the job. So one way to approach it is to say, and sometimes an interviewer might actually get out the position description and say, here's the one task of the job. You probably wouldn't use the term essential functions because that seems kind of legalistic, but you might look at the position description and say, okay, well, here's the job description, and here's the first requirement. Would you be able to do this? Here's a second one. Would you be able to do this? Here's the third one. Would you be able to do this? Now, you don't have to say with or without reasonable accommodation. Um, that isn't necessary, but that would be implied in the conversation. Now, obviously, if the person is disabled or they volunteer that they're disabled, it's visually obvious, then would be a good idea to add, with or without a reasonable accommodation, would you be able to do this task? If the person appears to be able-bodied, then there's no need to add that additional language. If you're going to ask this question of disabled people, it's a good idea to ask this question of non-disabled people. So, and it's a good idea actually to ask these questions, whether you're dealing with a disabled person or non-disabled person, to find out, to go through the position description and to give the applicant an opportunity to say what he or she is able to do. But most of the time, the applicant is going to say, sure, I can do this, right? I mean, they want to get the job. And so they're going to say, yes, I can. So sometimes the more important question is going to be the follow-up question, which is, how would they perform that position? So let's say somebody is in a wheelchair, and one of the tasks of this position is to file. So you might ask the person, whether they would be able to perform the filing task in the job. And they say yes. And then you could ask them, how would they perform that task? And they would say, well, I would need to have the filing cabinets no higher than X high. And I would, you know, uh, whatever the other, there may not be any other things that they would need with respect to that. So those would be the way to approach it. Again, with the how questions, if you're asking disabled people the how question, you ought to ask the able-bodied people the same question. Um, that may seem a little silly at that point to ask them how. What do you mean? How would I file things? I would open up the filing cabinet, put the papers in alphabetical order, right? But if you're going to ask a question to the disabled person, especially if you know that one of the people you're interviewing is disabled, it's a good idea to keep your questions the same. And so you might then want to say, how do you go about accomplishing that task? And you might actually find out some interesting information. I actually um, once read a book about maintaining filing systems, and they talked about should you pre-file. If you have 100 documents, should you organize those alphabetically, and then go to your filing cabinet and because then you're somewhat organized. The short answer is yes, you should. It saves money, but that would be an example of a how. And so if you had a candidate who didn't say that he or she would pre-sort, then that person would probably take significantly longer with the filing task, and that person might be not the person you want to hire for that particular position. So the how can be useful even in non-disabled situations. Okay, so as we said before, you can't ask those disability related questions. And again, these don't have to be disability related questions, especially if you're asking them of all the candidates. But a disability related question would be, what kind of reasonable accommodations would you need? And those questions can only be asked after you've extended a conditional job offer. So let's go down here and see our definition for a conditional job offer. Again, if you don't already have this in your Quizlet, please add it. So obviously a conditional job offer is first and foremost a job offer. And it's a job offer that is conditioned on the employer's reasonable accommodation of the applicant's disability. So what you do into that situation is you say, we're extending you a job offer with the assumption that we're able to reasonably accommodate your situation. And so then you start the conversation about, well, what kind of accommodations are you going to need? Now, obviously, when the person appears to be able bodied, or in fact is able bodied, you don't offer a conditional job offer. That wouldn't make any sense because, or well, let me put it this way, you don't ordinarily do a conditional job offer because there is no reasonable accommodation. There is, though, a time that you would do a conditional job offer, and we'll talk about that in a few minutes. But the time that we really think about conditional job offers applying would be when the candidate has indicated that there is some need for reasonable accommodation. And so you offer the conditional job offer, and then you start the process, that reasonable accommodation process that we talked about in another lecture, I guess the third lecture. And so you work that out. Now, again, it's conditional in the sense that what if when you go through that process, you realize that there is no reasonable accommodation for this particular circumstance, or every reasonable accommodation would be an undue hardship for the company. And so therefore, you aren't actually able to extend a final job offer. Um, but then at least the candidate knows, well, I would have gotten the job, but for the lack of, or the employer's decision that reasonable accommodation isn't possible. So then the employee that, or not employee, but that failed employee, or that person who didn't become an employee, is able to file a charge of discrimination because maybe the EOC or the court system will say, well, no, we think a reasonable accommodation would have been possible. Okay, so when you're going to use a conditional job offer, when you're not talking about the reasonable accommodation process, but you are going to require some kind of medical examination, then you're going to use the conditional job offer for everyone, not just disabled people, but for all people. Some employers, especially if the job is especially physically demanding, or there's exposure to chemicals or something along those lines, may require that all candidates go through some kind of medical examination before they begin. This may ensure that the person isn't someone who's likely to experience injuries as a result of the employment. And these medical examinations can only occur after the conditional job offer. So you might have a person who is not at all disabled, but still isn't successful on his medical examination. He's perhaps an older person or just not physically fit. And so he has or she has not passed the medical examination. The conditional job offer does not become a real job offer. That can happen, and under those circumstances, the successful non-disabled applicant isn't going to have any recourse, most likely, unless, of course, he can argue, well, I actually do have a disability. So the conditional job offer would apply to non-disabled people when there's a medical examination issue. So we've completed our first topic, which is probably our most lengthy topic, which is the topic of hiring. Now let's talk about the topic of harassment. Not all circuits have recognized disability harassment, but it seems like such an obvious extension of the law that I think that that's definitely the trend in the law. And really, in circuits that have recognized disability harassment, the law tracks very closely with the Felliger and Eller decisions with the analysis that we see in Title VII in disability cases. And of course, we really don't, we're really talking about hostile work environment when we talk about disability harassment. And of course, we've talked about this term before, but if you don't have it in your Quizlet, go ahead and add it. It's a work environment in which harassment of an employee exists to such an extent that a reasonable employee would dread or fear going to work. So it's not a trivial type of situation. So the same analysis we did in Title VII for sexual harassment would apply to disability harassment. Now, not surprisingly, disability harassment claims are relatively unusual. Most people have compassion for people who are disabled, but every now and again it can happen. Probably it happens most commonly with people who are recovering drug addicts or perhaps have mental health disorders. And so maybe they have been teased or ostracized in some way. The standard for harassment remains high, just as we saw with Title VII. It must be severe or persuasive. So, just a few comments, especially if they're not too serious or not going to qualify as hostile work environment disability harassment. Let's talk about contingent workers. We've talked about this also, especially when we're talking about the differences between temporary and permanent workers and between independent contractors and employees. So if you have a contingent worker, typically or oftentimes that means that they are actually employed, the worker is employed by the staffing firm, and they go to work in the physical place of the prospective employer, but the employer pays the staffing firm and the staffing firm pays the contingent worker. Well, in that situation, both the prospective employer and the staffing firm are required to reasonably accommodate the contingent worker. There are tax incentives available for both the prospective employer and the staffing firm, and these can be used to provide workplace access. In fact, sometimes the staffing firms may specialize in disabled workers. For example, organizations like Salvation Army or Goodwill might function in that role to get individuals into the workplace. But these tax incentives can help allay the costs of physical plant changes that must occur to accommodate the needs of the disabled worker, which that might include architectural changes or transportation issues, how to get this person to one work site to another work site, that type of thing. And again, we've already talked about vocational rehabilitation referrals, as somebody may be transitioning from a more limited situation, more a greater disability to a lesser disability, or perhaps somebody who has an intellectual disability. These types of programs can be helpful to get those individuals in the workplace. Let's discuss retaliation. This, of course, remains an issue just like we've seen with Title VII and the Age Discrimination in Employment Act. Just like those laws, it prohibits discrimination against anyone, and this would include the non disabled too, not just the disabled. But anyone who makes a charge, testifies, assists, or participates in any manner in an investigation, proceeding, or hearing. Interference, coercion, intimidation are also forbidden. So, this is the one area really that we see non disabled people being able to assert rights. Well, also, we see this with association discrimination and with regarded as discrimination. But we can see here, let's imagine that you are able bodied and there's a disabled person in your workplace, and you feel that that person is being denied reasonable accommodations. Perhaps that person chooses not to file a charge. Well, you as the able bodied person can file a charge on behalf of that disabled person. And in that situation, when you file a charge, let's say you're discriminated against, the employer would naturally find out you filed the charge and could retaliate. Well, then, under that circumstance, even though you're able bodied and no one is regarding you as disabled, you could advance a theory under the ADA because you have a retaliation claim. Now, it's not 100% clear what remedies you would have under a retaliation theory. You definitely would be able to collect lost wages, attorney's fees, and equitable remedies such as reinstatement. It's not as clear whether you'd be able to get punitive or compensatory damages. Um, you certainly would likely plead for that and hope you'd get it, but you may or may not be able to. That's a developing area of the law. Let's consider workers' compensation. We're going to do a much deeper dive in this topic in a later lecture, but this is relevant to the topic of medical issues, and so I wanted to touch on it here. Here's a definition again for Quizlet. Workers' compensation law is a statutory scheme or system to provide no fault insurance for lost wages and medical expenses resulting from work related injuries. Workers' compensation law has been around for a very long time, since the early 1900s. It is not designed really to address disability issues, and it really has many different purposes. But certainly, somebody who becomes disabled as a result of a work injury would have remedies under workers' compensation laws as well as ADA. Um, Not all injuries at work are going to lead to workers' compensation liability, and that's especially true in Texas because of how our workers' compensation law works. And we'll talk about that in a later slide. Negligence is a tort theory. Let's first talk about the word tort. Tort is a private wrong against a person or his or her property. A particular type of tort is negligence. And negligence, again, this is another Quizlet term, is failure to meet the appropriate standard of care for avoiding unreasonable risk of harm to others. Now, in the case of workers' compensation claims, the plaintiff or the worker does not have to prove that any tort occurred or that the employer was negligent. And the reason that these aren't required to be proved is because this is a no fault system. And so no fault means there's liability for injury imposed regardless of fault. So the employer doesn't have to have done anything wrong. The employee doesn't have to have done anything wrong. The only issue is, did it happen at work and is there an injury? And once those two things are proven, then under workers' compensation statutes, the employee is going to be covered, except maybe not in Texas. Um, so let's talk about the liability for employers. So the general scheme works this way, and I say most states. We'll see that Texas does not fall in the category of most states. So this is how it works. So the employer makes payments into a common fund based upon its number of workers' compensation claims. The more claims the employer has, the higher the experience rating is, the higher percentage of the payroll the employer has to pay. In some states, you literally pay it to the state because the state manages all the money. In other states, You can hire private insurance. Liberty Mutual does a lot of this work. Um, when the injured employee becomes injured, the injured employee cannot sue the employer, even if the employer committed a tort, even if the employer was negligent. The only remedy that the employee is going to have is through the workers' compensation system. And the employee is going to get a schedule, a schedule exists that says if this happens to you, you get this. If you, God forbid, your finger gets lopped off, your pinky finger on your left hand gets lopped off, this is how much money you get. Or if you break your leg, this is how much money you get. And so it's a list of this is how much this injury is worth. Now, that's there are definitely cases that fall in that category, but there's a lot of gray area. Obviously, how injured a person is oftentimes a very subjective evaluation, and so there can be a lot of litigation in this area. Generally speaking, workers' compensation claims are not big ticket items. It's relatively rare that a person gets a significant payout. Again, the employee can't sue. And so what the employee is getting is a pretty much guaranteed payment, but it's not the big payment that he or she might have gotten in a court of law. So you get something, but you don't win the lottery. And as I said before, the injury must arise out of or in the course of employment. And this is oftentimes an issue that becomes important in the litigation of the case. Let's consider this scenario. So Bob works as a machine operator, and this company is a workers' compensation subscriber, meaning that it participates in this system. We'll learn more about this in the next slide. One day, while getting a machine started, Bob slips and falls from a ladder and breaks his elbow. So his injury arises out of the course and scope of his employment. Under these circumstances, Bob is covered under the workers' compensation schedule because he's able to prove his injury arose out of the course of his employment. Okay, so let's talk about what makes Texas and also Oklahoma special. As far as I know, these are the only two states in the United States that gives this particular option to employers. So in Texas, employers can what's called go bare, meaning they can opt out of the statutory workers' compensation system. So if an employer opts in to the system, it works just like this in Texas. The employee doesn't have a choice. If the employer opts in, then this is what the employee is going to use in the event that the employee becomes injured at work. But let's say the employer chooses to go bare, chooses not to participate in the workers' compensation system. In that situation, the employee is going to be able to sue the employer. So, this aspect of the system that we talked about before no longer applies if the employer has chosen to go bare. So now the employee gets to file a lawsuit for a tort claim, and of course, a specialized tort claim being a negligence claim. Um, and so the employer, by going bare, is risking the lawsuit, but is also saving some money because it's not having to pay into the common fund. So there's a risk associated with both approaches. In Texas, it's rather popular for employers to go bare. Employers that choose to go bare have to post a particular notice to that effect. Okay, so let's talk about genetics. Here's a definition of genetic testing. This is the analysis of chromosomes, genes, or gene products to determine whether a mutation is present that is causing, typo here, or will cause a certain disease or condition. And the relevant statute here is GINA, Genetic Information Non-Discrimination Act. We'll talk more about this in another presentation. Generally speaking, you can't do genetic testing on employees, and you certainly can't use that information against employees. Oh, well, actually, I have it right here, but we'll have a more extensive discussion of this topic in later presentation. So the threshold for Gina is 15 or more employees. So this is the same threshold that we saw with Title VII. And so employers that have at least this many employees, this law applies to, and therefore those employees cannot request information about an employee's genetics information, and also can't consider that employee's genetic information in making any employment decision. GINA also prohibits varying the amount of premiums that have to be paid by employees to a health plan. So I can't pay more because I happen to have a gene that makes it more likely that I'll get XYZ disease. And I can't be denied health insurance because I happen to have a gene that makes it more likely that I will develop a particular illness. There hasn't been a lot of litigation in this area at this point, so we don't know as much as we will in the future, I guess. Okay, so now we're going to talk a little about the Family Medical Leave Act. Boy, the Family Medical Leave Act is a really complex statute. One of the most complex ones that we'll deal with in this course. In my opinion, much more complex than the Americans with Disabilities Act. So we're not going to do a deep dive here, but I want to show some similarities and some differences. And naturally, there is a fair amount of similarity between these two laws, especially when we're looking at a situation where the reasonable accommodation that the parties are examining under the ADA includes a leave component. So let's consider briefly what the FMLA or the Family Medical Leave Act provides. It gives the worker up to 12 weeks a year of leave for covered conditions. Now, the definition of covered conditions under FMLA is much broader than the definition of disability under ADA. So many things that aren't disabilities are going to be covered by FMLA. The 12 weeks under FMLA doesn't have to happen in one set time period. It can cover, very short periods of time over the course of the year. But certainly, if something is a disability under the ADA, it would fall into the category of covered by FMLA. Certainly, under the ADA, 12 weeks of leave can be a reasonable accommodation. And in fact, I think after the FMLA was passed, it's very difficult for an employer to argue that that would be an undue hardship, especially if the employer has at least 50 employees. Here we go. Yeah, here. So the amount of workers that the employer has to have under the FMLA is 50 or more employees. So if the employer has 50 employees, it would be difficult for the employer to argue, well, we can't give that person 12 weeks off. Well, I mean, the FMLA requires you to do so. So how could you say it's an undue hardship? Now, not all workers, even of employers that have 50 employees, are FMLA eligible, but still, it would be a difficult argument to make under those circumstances. The interesting area here is going to be when the employee needs or requests more than 12 weeks of FMLA in a year. Can the ADA require as a reasonable accommodation that the employer give more than 12 weeks? And the short answer seems to be yes. Now, where the line is drawn, is 14 weeks the limit? Is 16 weeks the limit? And of course, the short answer is it's going to be a case by case evaluation, depending upon the employer's size, the needs of the employer for staffing, how unique is the position that the employee has, those types of factors. Let's consider this situation. So Mary is a staff manager at a local inn. She has a blood clot in her brain and is going to be on a 14-week leave of absence for her surgery. Unfortunately, she wasn't able to completely recover within the 14 weeks, and so she needs an additional 2 weeks. So her FMLA leave is past. She's already out of that. So this does not relate to an FMLA situation. The Melissa N informs Mary that her position might no longer be available when she returns from her extended leave, and Mary agrees. Under the ADA, obviously, the N must reasonably accommodate Mary's disability. Under these circumstances, it should find a vacant position for Mary at an equivalent level, or if not available, at a lower level when she returns. Now, this is assuming that the N could not reasonably accommodate Mary's 2 weeks to additional weeks of leave. Maybe it could, um, but certainly, most likely, it's going to have a hard argument for saying, well, we can't do 2 more weeks. And that's one of the issues that comes up with the ADA. Usually, the person doesn't come to you and say, I'm going to need 14 weeks. It starts out with a smaller amount, and then, well, I mean, many times obviously the person's able to come back earlier, but when you get to very lengthy times, it's usually, I need another week, or I need 2 more weeks, or I need 3 more weeks. And so then it becomes, well, if you've been able to tolerate this person being off 12 weeks, why couldn't you tolerate 2 more weeks? It becomes, and you might say, well, that's the straw that broke the camel's back, or that's a week that we're especially, those 2 weeks are a week that our hotel's especially busy. But it is a difficult argument to make if it's always, well, 2 more weeks, 2 more weeks, 2 more weeks. As we said before, the FMLA covers private employers with at least 50 employees. Obviously, the ADA threshold is, I think, 15. It's either 15 or 20. I've drawn a blank right here. But you can see it's significantly different. So there will be some employers who are ADA covered, but not FMLA covered. Under the FMLA, an employee is going to be entitled to return to his or her former position when the leave is completed. Um, the rule is same or equivalent position. Usually, though, the best practice is same because equivalent really has to be very, very similar. Again, we'll talk a lot more about FMLA in a later module. It's a very complex statute. Let's consider this scenario. Mary works as a waitress. She's 7 months pregnant. She's one of 57 employees, so this particular place is FMLA covered. Most, I think, restaurants probably aren't going to have that many. And she's worked on a full-time basis. And so she, under these circumstances, would be FMLA eligible. The doctor says that Mary needs to be on bed rest for her pregnancy, and so she won't be able to work for several months. So she asks her employer for time off. In this situation, yes, she would be entitled to 12 weeks of unpaid FMLA leave. But you can see that the ADA is not an issue here because pregnancy, even a high risk pregnancy, is not going to be a disability under the ADA. Now, it's possible that she has a high risk pregnancy because she's diabetic or because she has high blood pressure, and those conditions can be disabilities. So I'm not going to say that there's no circumstance under which there may not be an ADA issue, but generally speaking, most likely Mary is going to be covered just by FMLA in this situation. And of course, she's covered by the Pregnancy Discrimination Act, which is an amendment to Title VII. And now we're going to discuss Social Security disability. This is an important case in this area. Before we talk about the case, let me give you a little bit of an overview about how this works. Historically, and even today, when somebody becomes very, very ill or injured, they oftentimes will apply for Social Security disability benefits because they aren't able to continue working. And if they qualify for it, they are able to receive a benefit from the Social Security Administration. It's a very difficult benefit to receive before you reach your normal retirement age. The Social Security Administration has a very high threshold before it's going to award Social Security disability benefits to a worker. Historically, before the ADA was passed, many times this was the only way that a person who becomes disabled can, pay his or her bills, getting this benefit. And so what would happen is that the person who maybe had developed multiple sclerosis or had been in a bad car accident and wasn't going to be able to work, that person would apply for Social Security disability benefits. Well, one of the things that that person has to say in the disability application and has to testify to during the hearing is that they are totally disabled. They are not able to meaningfully work. Well, what happened after the Americans with Disabilities Act was passed is that individuals who weren't able to work out a reasonable accommodation situation with their employer would then apply for Social Security disability benefits, and they would make this statement that they were totally disabled. But at the same time, they may have filed a charge of discrimination against the employer based upon its alleged violation of the Americans with Disabilities Act because of its failure to reasonably accommodate the disabled individual. Well, what these employers would say is, wait a second, you, the employee, is talking out of both sides of your mouth. You're saying you're totally disabled at Social Security Administration, but you're telling the court here that you could have worked if we had reasonably accommodated you. One statement has to be true and one statement has to be false. You've perjured yourself. You shouldn't be able to get a remedy from us under these circumstances. So, anyway, this issue percolated up to the U.S. Supreme Court, and this is the issue that they confronted. Does the plaintiff's pursuit and receipt of Social Security disability insurance benefits preclude an ADA claim? And the answer is no, not in every case. The Supreme Court held that under some circumstances, a disabled person might receive both Social Security disability benefits and a reasonable accommodation under the ADA from the employer. And the reason that the court arrived at that benefit is that the Social Security disability definition doesn't uh, include language about reasonable accommodation. And so it's possible that a person can be totally disabled and still that disability could be reasonably accommodated. The court also acknowledged, though, that there is definitely a tension here between saying you're totally disabled and also claiming that you could have worked with a reasonable accommodation. And so the plaintiff does have an obligation to explain how these two statements can be resolved or reconciled with each other. You do not need to know the name of this case, but you do need to know the general concept, which is a claim of Social Security disability insurance does not preclude an ADA claim, but it will need to be sufficiently explained by the plaintiff. So we've covered now all of the topics in this module. We've talked about the prima facie case, the key ADA concepts, and how they relate to the reasonable accommodation process. We've discussed special disability situations, for example, a drug and alcohol addiction, and intellectual and mental health disabilities. We've discussed the remedies that are available to successful plaintiff, and we discussed some special topics. Now we're going to discuss some management tips, some ideas that you've probably picked up already, but we're kind of putting them into one location that will be the types of advice that you and the attorney will give to your clients. One thing that's important is never make assumptions about a worker. Never assume what they can and cannot do, and what they need or don't need. That's patronizing. It's oftentimes very inaccurate, and not a good idea. Not good for morale either. It's a good idea to review job descriptions to make sure all the job requirements are actually necessary to complete the job as it exists today. Perhaps in the past it was necessary to do X, Y, and Z, but maybe the job has been reimagined since then. Focus more on what needs to be accomplished, not so much on how it's going to be accomplished. When an employee shares a disability diagnosis, be sure to engage in that reasonable accommodation process. Ask questions. That employee is going to be the expert. Also recognize you may need to get information from the physician or healthcare provider. Follow the rules about when medical examinations can be required of the disabled individual. Make sure that the application you're using and the interview questions that you're using are appropriate. This is so important. Train all interviewers. The reality is, you don't always know when the next candidate who was going to walk in the door may be disabled, and you want to make sure that the interviewers are prepared. And this is going to involve periodic refreshers. Training a year ago is not going to help the person who has never really actually had to do it. And the person who walks in out of the blue is disabled or says something in the interview. The interviewer is going to be in a very uncomfortable position, not sure what he or she can do, and may well say the absolute wrong thing. Make sure that when you're engaging in the reasonable accommodation process, that you are listening to the employee, that you are brainstorming, coming up with creative solutions, that you're open to a variety of solutions. One thing we haven't talked about is maintaining the personnel file. Um, any information about a person's disability status should not be in their main personnel file. The ADA requires that there be two personnel files developed, and this applies even to individuals who aren't disabled. Perhaps I'm fully able bodied, but I happen to had to miss work for a day and I had a doctor's note. Well, my doctor's note should not go into my main personnel file. There ought to be a separate file for medical information, even though I'm not disabled at all. And certainly for disabled individuals, there needs to be that separate file. Okay, so here's a summary of the key differences between Title VII and the ADA. We've talked about these before, but I thought it might be helpful to have a one-stop shopping type of situation. So under ADA, federal employees cannot use the ADA. They have to use the Rehabilitation Act. But federal employees can use Title VII. Under the ADA, there is no BFOQ. We saw that under Title VII, you have BFOQs for religion and sex and national origin. You can't have it for color or race. Under Title VII, you can have reverse discrimination claims for all of the different theories, but under the ADA and also the ADEA, you cannot have reverse discrimination claims. The ADA has that concept of essential functions. The employer has to accommodate those, but doesn't have to accommodate non essential functions. The employer can just remove those functions from the job. Title VII doesn't have any concept like essential functions. Under the ADA, there's the need to reasonably accommodate the disabled. Title VII has a reasonable accommodation requirement only for religious category. The ADA limits an employer's ability to inquire about medical or physical issues. Title VII does not preclude asking questions about protected status, such as, are you a Methodist? Or, what is your national origin? Those questions are deeply stupid to ask, but they are not categorically unlawful. It's a very, very bad fact, but the ADA actually prohibits those types of questions. So Title VII doesn't absolutely prohibit them, but again, really, really not smart to ask those questions. I hope that this presentation has been helpful. I thank you for your attention. As always, if you have questions about the material, please pop into my office hours so we can discuss them in more detail. I hope you have a wonderful day. Take care.